Do you remember any sources of European Union law we have spoken in the class?
The Founding Treaties.
You know, you've heard about the Founding Treaties, regulations, directives, decisions, resolutions, opinions, recommendations, guidelines, general principles of
law, natural.
International law, European Union law,
Charter of Rights,
Charter of Fundamental Rights, doctrine,
Delegate Acts,
Case law.
act, case law, international agreements. Okay, we will be dealing with some of them, most of them, but not all of them. We don't have time to deal with them one by one. There you will find different charts on sources of European Union law in different books. I'd use this one, but you can please feel free to any chart you find better than this one. All right? Sources of European Union law is divided into two as written and unwritten sources. The written sources are divided into two as primary sources and secondary sources. The primary sources of European Union law include the Founding Treaties, the Amending Treaties, Accession Treaties, the annexes, declarations, protocols to these treaties. Secondary written sources include regulations, directives, decisions, international agreements, and recommendations and opinions. Unwritten sources include the decisions of the Court of Justice, of the EU, general principles of EU law, general principles of international law. We have mentioned resolutions, we have mentioned guidelines, etc. They are also part of sources of European Union law, which are not considered as legislation. Legislation, in a strict sense, would mean legislation in Turkish. Mevzuat. Resolutions, for example, non-binding. Recommendations, opinions, non-binding. Therefore, they are not considered as a part of legislation, but they are considered as sources of European Union law. All right? I will explain some of them in detail. I will leave the others to you to read from your chapters. The first one is the Founding Treaties. The Founding Treaties. What are the founding treaties of the European Union, the original treaties that established the European Union? One, Paris, two, Rome treaties establishing the European Coal and Steel Community, the Euratom, and the EEC. Then the Treaty on the European Union, coming from the Maastricht Treaty. These were the original treaties that have established today the European Union. Today, when you need the founding treaties, which ones do you look for?
EU treaty and the treaty on the functioning of the European Union.
Okay, today we have not 2 but 3 founding treaties. We use 2 very often. We don't use the third one, but it still exists. The EU Treaty and the Treaty on the Functioning of the European Union we use very often. The EU Treaty provides for the general aspects mostly of European Union law, and the details are provided by the Treaty on the Functioning of the EU. What is the Treaty on the Functioning of the EU? Is it a new treaty?
After the Lisbon Treaty, yes.
Is it provided for the first time by Lisbon?
No.
No.
This was the Constitution.
No? What was the Treaty on the Functioning of the EU? Its name is changed only by the Lisbon. No.
Wasn't
No.
it a constitutional treaty?
There's the draft, it went to the bin. No constitution. When the EU or when the European communities first established, we had 3 founding treaties. Is that true? These are the original treaties that have established the European communities, okay? Tell me the amending treaties. We start from the end? Okay, Nice. Amsterdam. Maastricht.
Budgetary. Single European Act. Merger.
Okay. Before the Treaty of Maastricht, we had only these 3 treaties. Is that true? Yes. Before the Treaty of Maastricht, I will explain you in very general terms, okay? Before the Treaty of Maastricht, the amending treaties, these are the amending treaties. Please, when I say founding treaty, don't answer me as Maastricht or Amsterdam or Lisbon, okay? These are not founding treaties. These are amending treaties of the European Union law. Before Maastricht Treaty, the amending treaties amended these founding treaties. Okay? If you ever, and please look at the website of the European Union for example, the Lisbon Treaty, the Treaty of Lisbon. When you open the Treaty of Lisbon as such and read its provisions, you would not understand a word. You would not understand the substance of European Union law, because as an amending treaty, the Treaty of Lisbon only amends the already existing provisions. For example, it is not always like that, but in most of the time. For example, the co-decision procedure, you know, is amended by the Treaty of Lisbon and replaced by the ordinary legislative procedure. The name is changed, okay? In the Treaty of Lisbon, you would find, for example, in Article 15 of the Founding Treaty, the word co-decision is replaced with ordinary legislative procedure. So you would not understand the substance, what is meant, what is the procedure to be followed under the ordinary legislative procedure, okay? Or, for example, it will say the number of seats in the European Parliament is changed to 70-51. You will only read 70-51 to be changed by the Treaty of Lisbon. Please take a look at an amending treaty. Therefore, and after the Maastricht Treaty, the Treaty of Maastricht also provided for an EU treaty establishing the European Union for the first time. It also amended the previous founding treaties. After Maastricht, therefore, these amending treaties amended this and this. Okay, as you know, European Coal and Steel Community expired in 2002. Therefore, the amending treaties continued to amend EEC Treaty and Euratom. Now the question is, today, how many treaties do we have? First, we have the EU treaty. We use very often for this class as well. This is this EU treaty, okay, as amended by these amending treaties, okay? When you look at the net, for example, I uploaded for you on Moodle the EU treaty as consolidated by the Treaty of Lisbon at the end. Therefore, the texts we read are already changed, amended versions, okay? Otherwise, we do not understand anything for this, for today's law. Then, which treaty do we have? The Treaty on the Functioning of the European Union. Now, what is this? What is this one? Is this a new treaty?
The amended version of Maastricht.
It cannot be Maastricht. This is amending. We need a founding treaty. Yes, this is the oldest EEC treaty. The EEC treaty was first amended by Maastricht as EEC treaty. Then the Treaty of Lisbon changed the name of the EEC treaty to the Treaty on the Functioning of the EU. You would remember the Treaty of Lisbon replaced the word community with union. There is no community anymore. There is only the European Union, which has got legal personality, and all the word communities in the founding treaties is now replaced with union. Therefore, the name of the treaty is also changed from EEC treaty to the Treaty on the Functioning of the EU. Okay? And lastly, do we have Euratom in force?
Yes.
Yes, it is still in force, but we don't use it very often because it's only about atomic energy. Now, therefore, we have 3 founding treaties in force, but we use 2 of them most often. The first characteristic of the founding treaties is that they are also called or considered as constitutional treaties. Founding treaties are also considered as constitutional treaties, meaning they have constitutional characters. What do we mean here? Yes, Deniz.
I mean, I understand from this word that in the hierarchy of norms, we understand that the founding treaties are the first.
Like constitutions?
Yes, take the first place in the hierarchy of norms. I mean, I understand that.
When we say constitution, Deniz understands that it is the highest norm in the hierarchy of norms in the EU. What else? We will come to that. When I say it has constitutional character. Yes, Öykü?
The institutions has to act based on the founding treaties, and their competences are listed in the constitutional treaty.
The institutions of the European Union, the competences, the powers, the compositions of the institutions are provided. Why?
Because it's the constitution.
It is, well, like constitutions, therefore. The constitutions provide for the powers of the institutions. We will come to that. What else? Yes, Deniz?
I can see that regulations, directives, decisions must be subject to funding treaties by being made, because otherwise it will be...
Because the founding treaties is the highest?
Yes.
Yes. What else? Yes, Kaan?
A constitution establishes a construction structure.
In a state?
Yeah, in a state and in a union.
Okay.
We can say it establishes constitutions and...
Okay. Yes, Deniz?
Only most important and general aspects are listed.
In an abstract manner, like constitutions. Okay, what else? The constitutions also provide for a very important subject. Fundamental rights. Okay. We call EU, okay, the first question is that does the EU, just to make sure, does the EU have a constitution?
No.
Sure?
Yes.
Yes, the EU does not have a constitution. Instead, it has founding treaties, okay? And we say that the founding treaties of the EU have constitutional characters. Here we mean mainly three things. First, like the national constitutions, the EU's founding treaties provide for the main powers of EU institutions. It provides for the powers, the compositions of the legislative, executive, and judicial organs of the European Union. It provides for the main principles to be followed by these institutions. It provides for the principles as regards the relationship between these institutions. Second, the founding treaties, like the constitutions, provides for the rights of individuals, for the fundamental rights. The European Union has now the Charter of Fundamental Rights for the EU, the Charter of Fundamental Rights for the European Union, providing for the basic fundamental rights of the individuals. It is attached to the founding treaties. It is attached to the founding treaties, and it has the same legal force with the founding treaties of the European Union. Other than that, the founding treaties themselves also provide for fundamental rights. Third, the founding treaties is at the top of the hierarchy of written norms in the EU. What do I mean with this? I mean that the secondary norms, the secondary instruments of EU law must be in conformity with the founding treaties. For example, when a regulation is adopted, it has to be in conformity with the founding treaties. But even the founding treaties must be interpreted according to the general principles of EU law. Even the founding treaties have to be interpreted according to the general principles of EU law. Therefore, we don't really say the founding treaties is at the top of the hierarchy of norms in the EU. This chart does not show you the hierarchy of norms because it is a debatable subject in reality, especially as far as the place of international agreements is concerned. This chart only shows you the sources of European Union law. All right? And even the founding treaties, therefore, must be interpreted according to the general principles of European Union law. But it is true, they are higher than the secondary norms of EU law. The second characteristic of the founding treaties is that they are not directly applicable. They are not directly applicable. What do we mean with that? Sorry?
They need to be interpreted to apply.
Interpreted? To apply. So any, or then there is no legislation or no instrument that is directly applicable because all of them needs interpretation. Yes?
They have to be the source for the secondary source, for example. For example, when you want to make a change and you want to have an act about something, you cannot show a founding treaty, but you can regulate a regulation or a directive or a decision.
No.
But it has to be in harmony with the...
No. No.
I thought that's why we thought that secondary.
No.
Like
No, we say secondary because they are secondary to the primary sources. They rank second. That these have to be in conformity with primary sources. Anyone else? Yes, what's your name?
Sena.
Sena.
They need ratification.
Bravo. They need ratification. What does it mean in Turkish? Yes, in English, ratification, onaylama. In English, transformation or transposition into the laws of the member states. I will explain you in the second hour. All right, 10 minutes break. The second characteristic of the founding treaties is that they are not directly applicable. What do we mean with that? We mean that they require ratification. The sources of European Union law, the written sources, which are not directly applicable, requires ratification. In other words, transformation or transposition to the laws of the member states. The only directly applicable instrument of EU law is a regulation, okay? The regulations are directly applicable because the founding treaties so require. It is written in the founding treaties that regulations are directly applicable. What would that mean? What happens if an instrument is directly applicable? Yes, Deniz?
They enter international legal systems without ratification, I mean transformation or transposition. I mean there is no need to transform the regulation anymore, so they are applicable.
How do we transform an instrument into national law?
Either referendum, the other one I cannot remember. It is legislated in their constitution.
Exactly. It is not provided in European Union law. It depends on the law of the member states. Therefore, it may be adoption of an act for that. Therefore, approval of the parliament of that member state. It may require approval of the parliament plus approval of the president. It may require referendum. Therefore, it is up to the constitution of that member state. But you need to adopt a certain instrument for that or ask to the public for its transformation. However, as far as the regulations are concerned, if, for example, a regulation comes into force today, that means the member states are obliged to implement that regulation by today in their member states, okay? There needs no ratification procedure or transformation or transposition procedure for the regulations. It is the contrary. When you try to transform a regulation in your national law, this is infringement of EU law, okay? Therefore, we will come to the regulations. Therefore, the founding treaties are not directly applicable. That means they have to be transformed into the national laws of the member states, all right? And it depends on the law of that member state how to transform a founding treaty. Thirdly, certain provisions of the founding treaties may be directly effective. Attention, they sound similar, direct applicability and direct effect, but they are not the same thing. There are different characteristics of EU law. Some writers use them interchangeably, okay, as if they mean the same thing. We do not use them in the same meaning. Direct applicability, we just spoke about. It's about ratification, transposition, or transformation of the instrument itself, okay? And we are sure about direct applicability in terms of which instruments are directly applicable, which are not. We are sure that regulations are always directly applicable. Why? It is written in the treaties, okay? It is not the same in direct effect, as you will see. Direct effect is about characteristic or it's a characteristic of certain provisions. Therefore, direct effect is about the provision itself. We speak about Article 12 of the Founding Treaty as directly effective or not. We speak about Article 45 of the Founding Treaty as directly effective or not. We will speak about Article, for example, 12 of an EU regulation as being directly effective or not. Therefore, when we discuss about direct effect, we always speak about the provision itself, okay? If a provision is directly effective, then it gives rights to individuals. It gives rights to individuals to be claimed before the national courts. A directly effective provision gives rights to individuals to be claimed before the national courts. What would that mean? This means that, for instance, a French citizen may go to French courts, attention, not to EU courts, the French courts, and may claim rights based on Article, say, 12 of the Founding Treaty, if that Article 12 is directly effective. If Article 12 of the Founding Treaty is directly effective, then a national of a member state, an individual, may go to the national courts and claim his or her rights. Therefore, directly effective provisions of EU law gives rights to the individuals to be claimed before the national courts. We will discuss about this principle of direct effect when we speak about Costa Enel decision, for example, or Wangen laws or Cimental cases, that EU law provides rights for the individuals when the provisions is directly effective. Direct effect in Turkish, doğrudan etki. Direct applicability in Turkish, doğrudan uygulanırlık. They sound similar even in Turkish too, but there are two different things, okay? So when do we accept that a provision is directly effective? Is it written somewhere? The answer is no. Neither the Founding Treaties nor any other instrument of EU law provide which provisions are directly effective. So when something is not written in the treaties, where do we look? We look at the decisions of the Court of Justice. Which provisions are directly effective? We look at the decisions of the Court of Justice. For example, imagine that French individual claimed his rights before the national court, saying that Article 12 gives rights to him, and he wants these rights to be implemented by the French government, okay? The first thing that French court will look is whether Article 12 of the Founding Treaty is directly effective or not, okay? Can the French court decide by itself on direct effectiveness of or direct effect of Article 12 by itself? It cannot decide. Why not?
Court of Justice.
Why Court of Justice will decide? It is true. Yes, because Article 12 of the Founding Treaty must be uniformly interpreted and applied by the member state courts. Who will do this uniform interpretation? The Court of Justice. Therefore, this French court has to stay the proceedings and ask to the European Court of Justice, is Article 12 of the Founding Treaty directly effective or not? How do we call this procedure? How do we call this procedure? Preliminary rulings procedure. Therefore, this is the preliminary rulings procedure. If the question is not asked to the Court of Justice before, then the National Court will ask, is Article 12 directly effective? The Court of Justice will tell. If it says that that provision is directly effective, then the National Court will tell to that individual, okay, I accept this case and I will look in the substance of the case, okay? If the Court of Justice says, no, this is not directly effective, then the National Court will tell to that individual, sorry, you cannot claim your rights before the national courts, okay? When the European Court of Justice decides on direct effect of a certain provision, be it in the Founding Treaty, be it in the regulation, in the directive, in an international agreement, it always applies the same three criteria. That provision has to be clear, precise, and unconditional. That provision has to be clear, precise, and unconditional. Açık, kesin, şartsız. Therefore, it depends on the provision. It depends on the interpretation by the Court of Justice. It applies, it finds out whether that provision is clear, precise, and unconditional. And the same criteria is always applied for the provisions of the Founding Treaties, for the provisions of accession treaties, the regulations, directives, decisions, international agreements. A clear and precise provision, provides rights for individuals the scope of which is perfectly defined. A clear and precise provision provides for rights for the individuals, the scope of which is perfectly defined. An unconditional provision does not provide for any additional act on the part of the member states or EU institutions or any kind of discretion for these institutions. An unconditional provision does not include or does not require any additional act or action for the institutions of the member states or for institutions of the EU or any kind of discretion for these institutions. What do we mean with this? For example, if a provision requires a national act to be adopted by the member states for its implementation, then is this a conditional or an unconditional provision? For example, a restriction should be prohibited by the member states through an act to be adopted by their parliaments, say. Is this conditional or unconditional? Conditional. This is conditional because for its implementation, it requires an additional act to be adopted by the member states. If it requires adoption of an act by the EU institutions, it is still conditional, okay? If it requires for discretion for any institution, it is still conditional. If it's conditional, then it is not directly effective. If it's not directly effective, then the individuals cannot claim any rights before the national courts, okay? Therefore, this is a very important characteristic of certain provisions of the Founding Treaties and other written sources of EU law. But as I've said, none of these instruments provide which provisions are directly effective. Therefore, it depends on the interpretation of the Court of Justice to decide whether the provision is directly effective or not. Students normally, it may be confusing for most of the students, direct applicability and direct effect. Please make sure that you understand them well at the moment. And you can ask me questions if you don't. Is it clear? Yes, Dennis?
So what do you understand by clear and precise? I mean, it's
the boundaries of the rights on the part of the individuals must be understood without any doubt from that provision. For example, to establish a customs union between the member states, the custom duties and charges having equal effect are prohibited. Full stop. Okay? There is no place for misunderstanding or vague terminology. The right of the individual or the obligation on the part of the member state is understood well from that provision. I will explain this later when we speak about the principle of direct effect as a characteristic of European Union law. But this obligation of the member state must be a positive or a negative obligation. A prohibition it could be, or a right on the part of the individual. We will come to that, all right, later on.
So, if the same article was also sent to European Court of Justice before, the French National Court will be binding.
Exactly, because this is nothing to be changed. We have spoken about acte claire doctrine. Would you remember when we speak about the preliminary rulings procedure? That is a principle, a national court against whose decisions there is no judicial remedy under national law is under an obligation to make a preliminary reference to the Court of Justice. But even that principle, even that duty has exceptions. And we said if the situation is clear, if it has been asked before and the answer is received from the European Court of Justice, then there is no need to ask it again. Direct effect is something like that. The article, for example, 12 of the Founding Treaty is either directly effective or not. If the court has said it is directly effective, then it is directly effective. It is not amended afterwards, all right? Therefore, once it is said by the European Court of Justice, there is no need for further reference to the court, all right? All right, another characteristic of the founding treaties is that other than the Treaty of Paris, establishing the European Coal and Steel Community, the founding treaties were made for an unlimited period of time. Therefore, the two treaties of Rome were signed for an unlimited period of time by the member states.
May I ask a question?
Yes, of course.
About unconditional. So we said that there is no need for approval of parliaments, member states, or approval of president, for example. So can we say that it is also directly applicable because indirectly applicable?
Sorry, direct applicability is about the instrument itself.
Okay, so it's about provision, yeah.
Yes. The founding treaties are not directly applicable. Why? They require ratification. Certain provisions of the treaties are directly effective because they are clear, precise, and conditional. Unconditional. Regulations are directly applicable. Certain provisions of a regulation may be directly effective. We are very clear, very sure about direct applicability. As I said, regulations are directly applicable, always, okay? But certain provisions of a regulation may be directly effective. We always speak about a possibility when we speak about direct effect because we don't know. If it's not decided by the Court of Justice before, then we don't know whether Article 75 of the Founding Treaty say is directly effective or not. We have to look, we have to ask to the Court of Justice. And the main tool for asking direct effect of EU instrument is the preliminary rulings procedure, that the national court stays the proceeding and asks to the European Court of Justice. All right? Because then it will tell to that individual that, okay, we can go on because the provision gives you this right, or no, stop here because you don't have a right to take a suit before the national court, to take an action. All right?
Can you categorize the provisions as directly effective or not? Like, is there any other options for the provision?
In terms of this,
Yeah.
rights of individuals, no. It is either directly effective or not. Okay. So we said that other than the Treaty of Paris, they are concluded for an unlimited period of time. The founding treaties are not classical international agreements. Of course, they are international agreements in essence because they are concluded between the member states, member states of the European Union. But they are not like international agreements because of the fact that their execution, their implementation are not done, or in other words, they are not only implemented by the contracting parties, by the member states, but by the EU institutions as well. Normally, who would implement an international agreement between two countries, for example?
Member states.
The states, the parties, the contracting parties in Turkish, contracting party? How do we call them? Akit taraflar veya taraf devletler. Who will implement an international agreement between states is the states to which are parties to that international agreement. Here, the founding treaties are implemented by the member states, but also by the EU institutions themselves. And the EU institutions, therefore, also execute the founding treaties of the European Union. An important question is whether withdrawal is possible from the European Union. The second related question would be whether dismissal is possible from the European Union. Yes, Sena?
They can not dismiss a country, but a country can withdraw from the European Union with the Lisbon Treaty Act.
Exactly. Withdrawal in Turkish? Yes. What is dismissal? Withdrawal ayrılma. Dismissal çıkarma. Withdrawal is not possible after the Treaty of Lisbon. What is not possible is dismissal. We will speak about them later. Is accession possible? It is provided the accession procedures is also possible under the treaties. The accession procedure is clearly provided under the founding treaties today. Do you know which states can be member to the European Union? Can all states apply to the EU for membership? Can the EU accept any member state? Yes, Deniz?
I think member states should be in the continent of Europe or close to the continent of Europe, and
Close meaning?
maybe Turkey, because not
Turkey is in Europe, no?
no, it's in complicated part.
We are European, come on. We are European. We have one big part in Europe, in the European continent, of course. Is Cyprus in Europe?
Yes, but
It's very close to Africa. That is also problematic. But yes, you say that we need a European country then. Do we need anything else to apply to be a member of the EU? Yes.
We should, our legislation should be in conformity with the European Union. Be accessed by the European Union.
To be accepted by the EU. Okay. Anything else? Yes, Deniz?
Countries, for example, which respect the rights of individuals or certain fundamental rights, rule of law, can be member state of the European Union. There are certain conditions for that.
Is it written in the treaties?
Not in Twitter, but I read it somewhere else.
Somewhere else? The treaties do not provide?
I don't know.
Sorry?
They do provide.
They do provide. What do they provide? The criteria. Do you know the names of these criteria?
There was some Copenhagen, I guess.
There was some Copenhagen, and then?
I don't know the other one because the popular one was Copenhagen.
But you were not alive then, were you?
I was.
You were, really? When were you born?
92.
Ah, okay, 1 year old already. Okay, true. The accession conditions are provided in the founding treaties. The treaties provide for accession process. This provision, which is now found under Article 49 of the EU Treaty, was subject to changes in the history of the EU for a couple of times. In the original Treaty of Rome, it was provided that any European state may apply to become a member of EEC. Any European state may apply to become a member of the European Union. At that time, when this provision was still in force, this was Article 237 of the EEC Treaty, Article 237 of the EEC Treaty. In 1987, Morocco applied. Morocco? Fas applied. And do you remember the first institution that prepares a report for the application of a third country to the European Union? When a third country applies to the EU, there is one institution of the European Union that prepares the first opinion on this application. The European Commission prepared the report for Morocco, and it said, sorry, Morocco is not in Europe. In the same year, in 1987, Turkey applied for full membership. The European Commission prepared the first report and said, what did it say? Turkey. The Turkish application in 1987 for full membership. What did the European Commission say? Commission said Turkey is in Europe, but Turkey does not satisfy the requirements for membership. Then this article, Article 237, was amended then by the Treaty of Nice. The Treaty of Nice, after the Nice amendments, it was provided under Article 49, and it said that any European state which respects the principles set out in Article 6, paragraph 1 of the treaty may apply to become a member of the Union. Any European state which respects the principles set out in Article 6, paragraph 1 of the treaty may apply to become a member of the Union. This provision, Article 6, paragraph 1, at that time, provided for the values of the EU, and it said that the EU is founded on the principles of liberty, democracy, respect for human rights, and fundamental freedoms and the rule of law. This provision is then amended by the Treaty of Lisbon. This provision is then amended by the Treaty of Lisbon. Today, we deal with this provision by dividing into two, as substantive requirements for membership and procedural requirements. For membership. Substantive requirements in Turkish. Maddi gereklilikler. Procedural requirements. Usuli gereklilikler. As far as substantive requirements are concerned, the provisions say that any European state which respects the values as provided under Article 2 and which is committed to promoting them. Can apply to become a member of the European Union. According to Article 2, any European country, any European state, which respects the values as provided under Article 2 and which is committed to promoting them, may apply to become a member state. The values as provided under Article 2 of the treaty are the following: human dignity, equality, democracy, rule of law, freedom, respect for human rights, including the rights of minorities. There is also one important sentence added by the Treaty of Lisbon to Article 49. It says that the conditions of eligibility as agreed by the European Council shall also be taken into account. The conditions of eligibility as agreed by the European Council shall also be taken into account. Then the question is, what are the conditions of eligibility as decided, as agreed by the European Council? We have mentioned that the European Council is the highest political institution of the European Union. I told you that the European Council used to meet in different cities of the member states. Do you remember? Now it meets in Brussels. In 3 meetings of the European Council, in 1993, in 1995, and in 1997, the European Council, the EU leaders, decided on the conditions of eligibility for membership. 1993 was the Copenhagen European Council, the Copenhagen European Council, the 1993 Madrid European Council, and 97 was Luxembourg European Council, where they decided for the conditions of eligibility for membership. The Treaty of Lisbon is important because for the first time there is now a clear reference to these conditions of eligibility. Okay? In Turkish we call them Kopenhag, Madrid, Lüksemburg üyelik kriterleri. And you are right, Copenhagen criteria or Copenhagen European Council was the most famous European Council in Turkey. The Copenhagen criteria includes mainly 3 criteria. Economic, political, and legal criteria. Economic, political, and legal criteria. Legal criteria is also referred to as acquis criteria. Acquis. Any idea? Usually it is used as acquis, but the longer version is acquis communautaire in French. What does it mean, Deniz? What did you say?
Sorry? Acquis communautaire, yes.
What is it in Turkish? What did you say? What you just said?
Müktesebat.
Müktesebat. Müktesebat. Is it the same with mevzuat, legislation? No. Acquis is far larger than legislation. Legislation in a strict sense is the regulations, directives, decisions adopted by the EU institutions. When we say acquis, we refer to all binding and non-binding EU norms, including the decisions of the Court of Justice. Okay, it is far larger than legislation. In the Copenhagen European Council, therefore, they decided on the economic, political, and legal criteria for membership. As far as political criteria is concerned, it is provided that membership requires that the candidate country has established the stability of its institutions, guaranteeing democracy, rule of law, human rights, protection of human rights, and the rights of minorities. Therefore, according to the political criteria, the candidate country must have established the stability of institutions, guaranteeing democracy, rule of law, human rights, and respect for the rights of the minorities. Economic criteria includes the existence of a functioning market economy, and the capacity to cope with the market forces and competitive pressure in the EU. It includes the existence of a functioning market economy and the existence of the capacity of to deal with the competitive market pressure and the market forces in the EU. Thirdly, the acquis criteria supposes that the candidate country has the ability to take on the obligations of membership. The candidate country must be in a situation to take on the obligations of membership, including the obligations arising from the political and economic and monetary union. The candidate country must be in a position to take on the obligations arising from the membership, including the obligations based on the political, monetary, and economic union. Any questions? Okay, then we will stop here and we will start next week from the Madrid criteria. All right?